Hi, it's April 2nd, 2016. This is the second of what turns out to be 3 videos on Griswold, Roe, and Casey. I had a little technical malfunction with the last video, that's why it ended abruptly. We left off talking about the 4 points on the outline after Roe, and I said there was a question about moving lines, a question about what the state's interest in potential life really was, how we would talk about that. And I left off talking about the question of framing and whether, if you're pro-choice, or especially if you're a feminist, and it's an interesting question in terms of political impact, no matter what your view is, whether the framing in Roe makes sense or makes the most sense. A lot of feminists have raised the question and objected, perhaps, that to frame this right in terms of autonomy and individual liberty may have not been the best way to go, and that maybe there should be some effort to reframe what's at stake constitutionally and morally and politically in the abortion debate. So when we talk about framing, it's a basic idea of you draw a frame around something, you focus on certain things, and you may exclude other things. So when we talk about legal framing, we talk about the legal translation or the legal grounding of a claim. And the point here is that it might have been better for feminists and courts to have framed the abortion right in terms of women's equality. And there you would go to the Equal Protection Clause, no state shall deny to any person the equal protection of the laws, rather than the Due Process Clause and the word liberty. So why would denial of reproductive freedom, or specifically abortion rights, be a denial of equal protection of the laws? Why would it be a matter of discriminating against women as women? Well, the abortion procedure is a medical one that only women need. Restrictions on abortion impose on women alone the burden of serving the state's interest in potential life, setting aside again what that is and whether the state actually should be said to have that interest. But women, whatever it is, women alone bear the burden of preserving it or protecting it. And I think most fundamentally, abortion is a procedure that women need access to have equality with men in the marketplace and in competition for positions in life, and be able to have an equal chance of holding positions of political power. And maybe most broadly, equal citizenship may be said to depend on it. That would be the argument, that would be the equality argument. And I do think also that legal frames kind of invoke, have historical and political implications. So if you go to the Equal Protection Clause and you make an equality argument, you might think of the analogy of the Civil Rights Movement and its focus on getting rid of legally mandated segregation. You start to look at history. If you do that, you start to look at groups classified and defined as groups, with some groups having a superior dominant position and some groups having a subordinate position. And you start to look at the history of those group relations. So here, if you frame the abortion right as a matter of gender equality, you might tell a historical story about men controlling women by controlling their sexuality and reproduction. A different kind of political implication, I think. And then the question is, well, if that's embraced in law as an argument that holds up and has constitutional significance, then what would be the implications in politics for political struggle of that different legal frame? These questions aren't really answerable precisely, but they're interesting to think about. This is not what we find in Roe. I mean, in Roe, if you read the full opinion, it's a history of the fetus, and it's almost like the woman isn't there. It's like there's the womb, the fetus, and what doctors and lawyers and theologians have thought about it. Very different historical analysis. And to the extent you can envision a woman when you read the rhetoric in Roe, I don't know, I see her standing next to a guy in a white coat. The way Blackman writes it, it's the physician and his patient are going to make the decision, as if it's really his dilemma. And the doctor is, presumed to be sort of a male figure in the rhetoric of the opinion. So there is a kind of a paternalism in there in the way he writes it. He evolved. He had, Blackman had a kind of a different take on things by the time we get to Casey, as he had a different take on many issues over the 70s and 80s, most notably the death penalty. But the two frames are not really mutually exclusive. You can argue both, and advocates often do argue both, but law tends to go in a particular direction and not another direction, and then it narrows as it frames. So we're going to see this same framing question, should gay rights claims, like we see in Bowers and Lawrence and the same-sex marriage case, should those be equality claims, matters of group equality, or are they better framed as individual autonomy claims? And again, I think the political implications of either frame are interesting to think about. There could be pros and cons on both sides of the question. All right, and then the fourth point on the outline is something we're not going to talk about, but I'm going to talk about it for 30 seconds. That's the impact of a landmark decision like Roe, or the impact of Brown v. Board, or the impact of some of the speech or religion cases we're going to look at. What's the impact of Roe? Scholars have debated these questions, particularly about Brown and Roe, since a very important book in the early 90s called The Hollow Hope, Can Courts Produce Social Change, or Can Courts Bring About Social Change, by Gerald Rosenberg. And Rosenberg made the controversial argument that Brown and Roe really have nowhere near the impact that are usually claimed for them, and maybe even were counterproductive in some ways. Roe, I think, the one way to look at Roe's impact is like, well, access to abortion, how many abortions. If you look at that state by state, Roe is an enforceable decision. You have to prosecute somebody to enforce a ban or a restriction on abortion. And if the federal courts are committed to Roe, as lower courts would be after Roe, then you can't really proceed against somebody who violates a state law that restricts abortion. So in states where women, would not have had access to abortion, they received access to abortion. The number of abortions in the country, which to me isn't really a great measure of Roe's impact, it's not about how many abortions we have, it's about access and choice, fluctuates. It's down lately. So I'm not up on what all explains trends in abortion rates, but we were at about 1 million a year for many years, 20 years out from Roe. So then the other impact is the political impact. I mean, some people think that Roe made pro-choice forces disengage from politics around reproductive rights. You won, and you don't have to worry about it, because if there's any problem, the courts will step in and protect what you have. Whereas the people who had moral or political interests in resisting Roe were mobilized by it. So this is sort of a backlash argument. And again, this is difficult stuff to figure out and parse out. Would any national decision, if Congress had done what the court did in Roe, would that have produced the same kind of mobilization from people who were threatened by the abortion right, either because of their moral principles or their political interests? We don't know. I think there is a legitimacy problem in Roe that has to do with this claim that the court is just making it up, and this is a matter that should be left to democratic politics. All right, just to wind up this next segment, so there'll be a third video that will pick up the story with the Reagan era and go through the 80s cases and Planned Parenthood v. Casey in some detail. But I want to just bridge the space between 1973 and Reagan's election in 1980. And there are three areas. I mean, no Supreme Court decision kind of resolves everything. There are three areas that are kind of left hanging after Roe, and people who are opposed to abortion are going to look for, ways to have their values reflected in law in the space that's left to them by the court's opinion. So it's an ongoing sort of controversy, and there are three big areas where state legislation is passed and called into question and challenged in court after Roe. One of these three areas is concerns spousal notice or consent and/or notice and consent provisions to parents that apply to minors who are seeking abortion. The spousal and notice is different than consent. The law could require a woman wanting an abortion to notify somebody, simply notify, or notify and get their consent. States did pass laws that required women to notify and or get the consent of their husbands before getting an abortion. The court's answer to that under Roe, and its answer to this date, is no. That violates the framework of Roe, or it's an undue burden after Casey. These have always been struck down. The state can't require a woman to notify her husband before she gets the abortion. That violates the right that a woman has to make a decision about her pregnancy. When we get to minors, it's a little dicier. If you think of a 13 or 14-year-old who's pregnant, wants an abortion, and what the state can or should do to regulate that process, the court's answer to that has always been that it's okay for states to require minors to notify and or get the consent of their parents, sometimes one parent, sometimes both, as long as, provided that if the minor has a reason not to go to a parent, the minor can opt to go to a judge. It's called judicial bypass. And then the judge plays the role of the parent. And, this is a little weird if you think about it. The judge's question, I think a judge's first question would be, are you mature enough to make this decision for yourself? And if you are, go ahead and make it. And if you're not, well, then the parent has to make the decision for you. The judge is the parent. What's the judge going to say? You're not mature enough to make the decision, so I decide you're going to have the baby and be a parent? No, I don't think so. So unless you're in Alabama, if the minor gets to the judge, I think it's pretty much a foregone conclusion. Pro-choice activists would worry about the deterrent effect of the law in the first place, that requiring the minor to go to somebody is going to make some minors not go to anybody and not get the abortion. That's the concern. The second area of state regulation concerns medical practices and procedures, and this could be a lot of things. Primarily, it's informed consent. This is different than notice and consent. Informed consent is a medical idea about what information you need to make an intelligent decision about a medical procedure, and many of you have probably experienced this, right? Well, this is what's going to happen in this surgery, and these are the risks, and here you sign here. And can the state, require that the patient be told certain things? Can the state require that the patient wait a little while after they're told that? Can the state regulate where, when, where, and who performs the procedure, and how can they do that? One of the more gruesome examples of this were duty of care provisions. Like if you're doing a late-term abortion, can the state require a second doctor to be on hand to save the fetus, if they should be outside the womb alive? Can the state require certain medical tests to be performed? Now, the court's answer on pretty much all of this stuff right through 1983 is no. They took a pretty hard line on this stuff, and these things were not allowed in the first trimester. And in the second trimester, they were sort of rigidly looked into and scrutinized for whether they really promoted a woman's health or not, or whether they were pretext just to get in the way or raise the cost. And so this court is from 76 to 83 striking down a lot of these kinds of measures and shoring up the rule book nature of the trimester framework. More recently, starting very clearly with Webster in 1989 and in Casey, the court has been much more lenient about these medical procedures and their justification. the case that's now before the court on laws that place restrictions on who can perform abortions and their proximity to hospitals and the doctors needing admitting privileges at hospitals, which have the effect of sort of putting a bunch of abortion clinics out of business. This is Texas and Louisiana. It's going to be interesting to see how the court handles these matters against the backdrop of allowing, similar things, but with the undue burden test. So that's two areas. Notice and consent provisions, where the person wanting the abortion has to tell somebody else or get their consent. To medical practices and procedures. The third area is the issue of public funding. And here you might have thought, well, this is a fundamental right. And we do sometimes say if you have a fundamental right and you can't afford, a lawyer, right? You have a fundamental right to counsel. You can't pay a lawyer. The state has to provide you with a lawyer at its own expense, or else we can't say you've gotten due process in a criminal trial. Well, would the abortion right be like that? If you're too poor to buy one, does the state have to provide one to you and pay for it? Because it's a fundamental right that you have. We have the Mahar case. It's a 1977 case about whether the states can, under their Medicaid laws, exclude a non-therapeutic abortion from reimbursement, even though they pay for health care for childbirth. So if you're carrying the pregnancy to term, you get the payment for the medical care, but you don't get you don't get reimbursement for a non-therapeutic abortion. And that law is challenged under Roe, and the court upholds it, that there is no constitutional right to have it paid for, and there's no constitutional equal protection right about the state funding healthcare for childbirth versus not funding healthcare for abortion. And another case in 1980 also upheld a rule that Congress passed that Medicaid funds could not be used for non-therapeutic abortions. Many states choose to provide Medicaid funding for abortion. About 25 do, but many don't. And here we might get back to this framing issue. If it's framed as a matter of equality, you might have a stronger case for public provision for the poor. I think you would. As opposed to individual autonomy, which is, just the state has to not be responsible for depriving me of the right. The state didn't create my poverty, so the state's not on the hook if it's an individual autonomy right to actually provide access to it. So the court's answer on whether governments have an obligation to pay for it for the poor has been no, that's not entailed in the right. Okay, so this brings us to the point where we're going to look at the Reagan appointees, the cases in the 80s that seem to be setting Roe up for failure, Bowers for being overruled, Bowers v. Hardwick, and Webster v. Reproductive Health Services, the Missouri case from 1989. And then we're going to go through Casey in some detail. So I'm going to stop here, and so this is the second video. It's over. There'll be a third video. Now I created this third video a couple years ago, but you'll see it's for another class, but it does the work and it saves me the 45 minutes of creating another one. Okay, take care. Bye.